So good morning, everybody, and thank you for attending our online open house to discuss and present some information about the first draft of the what will be eventually here, the new land use bylaw for the summer village of Argentia Beach. For today's presentation, we're just going to go a little bit through, do a brief introduction of who we are, so you know who's talking to you. And then we'll talk a little bit about the logistics of how the online engagement session will be run. And then provide you with some information about the purpose of our meeting today, a little bit of information about how this document and the review process was guided by the Summer Village's new municipal development plan. And then we'll give you a brief overview of what a land use bylaw is and some of the areas that we're looking at revising, reviewing, updating as part of this process. And then we'll provide you with a bit of information about the structure of the draft document and how it's different than the existing land use bylaw, and then some of the information in the document. As we go through, we had a couple of polls that we had included in the presentation. I'm noticing we have a very low attendance today in terms of our members of the community that are with us. So I'm not sure whether or not there's a whole lot of value in doing those polls. Perhaps what we might do instead is update our online questionnaire that we have using SurveyMonkey to include those questions. I'm just thinking as we go, Brad, but I think that might be the way to go. Does that make sense to you?
Sorry, can you repeat that again, Jane?
Oh, rather than running through our poll questions with our two members that are with us today, I think maybe there would be more benefit in putting them out there to the whole community by updating our SurveyMonkey questionnaire.
Yes, absolutely.
Okay, so perhaps we'll do that. And then we'll conclude our presentation part of the meeting today with some information about how you can provide us with your feedback on the draft document once you've had the opportunity to have a look at it and had a little bit more information from us through the presentation today, and then what our next steps will be. So a little bit about us. You might recognize my name. You may not recognize Brad. Brad is another planner with Municipal Planning Services with our company. He also happens to be my husband. So he's joining us today from the living room, and I'm in our office in our house. Allison Roseland, you may have provided some assistance to the Summer Village in preparing your new municipal development plan. And we're also provided some assistance to the summer villages on the north side of the lake in the county of Wetaskiwin in the preparation of the Pigeon Lake North Intermunicipal Development Plan. Both of those projects were undertaken in the last couple of years. Municipal Planning Services, the company that we work with, also provides subdivision and planning advisory services to the summer village and 9 other summer villages around Pigeon Lake. So we're quite familiar with the area and a little bit with the history of your particular community. And certainly some of the planning and development related matters that you have been addressing or working through over the last couple of years. As part of the planning and subdivision services that we provide, our offices would process subdivision applications as well for the summer village. So that's just a little bit about us and our background. The firm is a planning advisory firm. We're based out of Edmonton, but we work exclusively with municipalities and not-for-profits doing this type of work. So in terms of logistics for our meeting, Brad mentioned that we're live streaming to YouTube because we recognize that really there's no good time to hold a meeting like this. It's never good to hold a public consultation session for a summer village during the winter, because often people are already not thinking about the lake. They've moved on to the things that they're thinking about during the winter months. However, during the summer, especially a beautiful weekend like this, there's a lot of competition for a meeting like this when there's so many beautiful things you can be doing out at the lake too. So in order to ensure that we can get this information to as many people as possible, the presentation will be live streamed and then recorded, and we'll provide Sylvia with the link so that anybody who was unable to attend has the ability to review the information over the next few weeks. So the purpose of our meeting today is to provide you with a bit of information about updates to the Summer Villages Land Use Bylaw. our intent today is to provide you with background information and an overview of what's in the draft land use bylaw right now, and then share with you opportunities for you to be able to be involved with the process and provide us with your feedback and input. We have a draft document. It has been reviewed with council once, but we're really quite early on in this project. So there is lots of opportunity for you to be able to provide us with your thoughts, feedback, let us know which changes you support, or if there are any areas or changes that we've made that you have questions about or you have concerns about too, and really influence the process. All of the information that you provide us as we move through this process, we'll gather over the next few months, share with council, and then we'll provide you with some additional updates moving forward as we do the compilation of the engagement materials and the agency responses, and then we'll make that all available for you to see. So one of the things that I think is important now to try to describe is the relationship between the land use bylaw and the Summer Village's new municipal development plan. So you do have this new municipal development plan, which was approved in November of 2020. That process and that plan were guided by council and feedback from the community through the public engagement process. And those of you who participated in that process will remember that it was an interesting and quite engaging process. Lots of different opinions and views about what the future development pattern for the community should be. So we worked through those discussions and those ideas as we went through that process, and really this process, the updates to the land use bylaw, in part the intention of that is to ensure that the land use bylaw, which is kind of the toolbox for determining how development will look within the community, is consistent with the vision, the goals and objectives that are in that municipal development plan. And therefore, we have a document that will enable us to ensure that the vision that's in that MDP, that we have the tools that we need in order to achieve that vision that's expressed in the MDP. It is important that a land use bylaw be consistent with the municipal development plan. So not only is it a good idea to make sure that the two are in alignment, but there's a requirement to do so. And so that's one of the other reasons why this project is being undertaken. So some of the noteworthy, I think, direction points from the MDP that certainly influenced our process moving through here were to promote collaboration and cooperation with regional partners and neighboring municipalities, to work to ensure that future development is well planned and designed within the Summer Village to mitigate environmental risk, and to incorporate watershed management planning best practices where appropriate to do so. So those were some of our, I guess, guidelines moving forward with the land use bylaw review. This is just a map that identifies the future, preferred future land uses. And this is a map from the municipal development plan. You are a small community, right? You don't have a very complicated set of existing land uses. And through that process, it was identified that the intention was to ensure that the development footprint and pattern stay as consistent moving forward as it is today. So the future land use map identifies a residential area and then your recreation and environment area. The residential area are those areas where the Summer Village has existing residential development and supports existing redevelopment. And then the green area there, the recreation and environment area, the areas within the community that are currently used for and are intended to be used in the future for recreation and environmental management purposes. There's the green belt area sort of along the back, and then it's difficult to see on this map because of the scale of it, but there's also some sort of spillway areas, and there's a reserve area along some of the lots between the residential lots and the bed and shore of the lake. That's the piece that's a little bit hard to see there. As we go to the slide that identifies the land use bylaw map, it'll be a little bit easier to see there. So what is a land use bylaw? Land use bylaw is a tool, really a regulatory tool that's mandatory for all municipalities in the province of Alberta to have. So Regardless of your size or scale, you have to have a land use bylaw. The land use bylaw establishes processes for subdivision and development, applications, notification, enforcement, and for the appeal process. Land use bylaw establishes regulations that would pertain to specific types of land uses and general types of land uses or development within the community. It also divides the summer village into different land uses or districts. Sometimes we refer to those districts as zones or zoning. But for the purposes of being consistent with the wording that's used in the legislation, we refer to them as districts in the document. The land use bylaw also identifies what types of land uses are permitted or discretionary uses within each of the land use districts. What's important to note about that is that if a use is not identified as permitted or discretionary in a district, then that type of land use is not allowed. And a good example of that, perhaps in a community of your scale, would be commercial uses. So you have a residential district, and then we have two residential districts currently, and then you have your sort of parks and environmental areas, and you don't have a commercial district. So your land use bylaw is quite simple in that it doesn't provide for commercial uses. They just are not uses that have ever been developed or considered appropriate within your municipal boundary. So there are no commercial uses identified as permitted or discretionary in the districts, and therefore they're not allowed within the summer village. Your existing land use bylaw, the bylaw that is currently in effect, has some shortcomings right now. And that was part of the impetus or motivation for doing this work and this project at this time. There's been some pretty significant or substantial changes to the legislation, the Municipal Government Act, which pertains specifically to land use bylaws and how the development process and subdivision process are required to occur within the province. So things relating to permit processing, notification, and the appeal process have all changed in the last couple of years as a result of these amendments to the legislation. And your existing land use bylaw doesn't reflect those changes. And so the language in the document, a lot of the procedural language relating to these particular matters is out of date, consistent with the provincial requirements. So it was important to update the land use bylaw in order to ensure that the language in the document and the procedural direction in the land use bylaw is consistent with the requirements that are in the Municipal Government Act. You also did what was a rather substantial amendment for a community of your size to your land use bylaw in the last few years too, which was to create the new residential district. So in doing the land use bylaw review, we can take amendment and consolidate it into the land use bylaw document so that everything is consistent and all in one place. That makes the document a little bit easier to use. And then in going through this process, we also are able to ensure that, as I mentioned a little bit earlier, the regulatory direction or guidance in the land use bylaw is consistent with the direction, the vision, the goals and objectives that are in the new municipal development plan and also in the new intermunicipal development plan, which is in effect for the summer villages on the north side of the lake and the county Wetaskiwin. So it enables us to ensure consistency, and everybody is sort of working towards as best they can the same types of development pattern in a way that's appropriate, I guess, for all of your different communities. I'll talk a little bit more about that as we move through. So in terms of process, we started this by identifying areas of focus with council and administration. And then we also chatted with council and administration about those areas that just from a procedural perspective, we thought needed to be updated. We believe need to be updated in order to ensure consistency with the legislation. And then we prepared the first draft of the land use bylaw, which we shared with council and administration. We reviewed that with them and they provided us with some guidance and direction. We updated the document to reflect that guidance and direction. And then that is the document that's posted on the Summer Villages website now and available for you to review. It hasn't been there for very long, so our expectation for you today is not that you have all have had the time to sit down and read through that. Our hope today is that with the information we're providing you through this process, It will enable you, as you do have some time over the next few weeks or so, to have a more detailed review of the document, to have a better understanding of why we made some of the changes that we have to the document, and then it should assist a little bit with your review. So there is also a newsletter that went out that had a link to an online survey that was circulated that we're hoping you will take a few moments to answer. The purpose of that survey is to help us gather a little bit of information about your views about some sort of specific development related matters. As of today's date, or I guess it would have been yesterday's date was the last time we looked, we'd only had 6 responses to that survey. So one of the things that I think we need to do probably is give you a bit more time to respond to that survey. For those of you who are joining us just a little bit later than the others, we had mentioned at the beginning of the presentation, because we only had 2 people in attendance at that time, that the poll questions we had as part of our presentation, we were perhaps not going to use, and that we would just update our survey to include them. I think we will still update the survey to include them, but Brad, because we do have a couple more people with us now, maybe we'll also do the poll questions as we go through the presentation. So if we put them in both places, then we should have the opportunity to get some feedback from as many people as possible. So our next step after today's session will be to give you a little bit of time to review the document, send us some information about your questions or any concerns that you may have with the draft document, and we will compile all of that information and answer those questions for you. I won't put you on the spot today unless you have some burning questions that you would like us to answer. For those of you who started with us a few minutes after we began the session, if you do have any questions, please send them in the chat to Brad, who will answer them if he can, and if not, forward them to me, and we'll try to get you some answers today too. If we can't, we'll follow up with you and get you some answers after our session today. So we'll prepare a summary of all of the information and comments that we received from community members, and we'll share that with council and administration, and then report back to you, the community. As we did with the Municipal Development Plan project, we'll make sure that all that information is hosted on the Summer Villages website, working with Sylvia, so that you can have a look at that and make sure that we have accurately recorded the comments that you've provided, and you can see any resulting recommendations or changes to the document as a result of your feedback and input. And then we will go over that with council and administration and make changes to the document as directed, revise that document and share it with you again so that you can have a look at those changes. And then we'll sort of work through that process, see how much time that takes to get to a document that everybody is comfortable with, maybe not 100% happy with, but can live with. And then we will start moving into the bylaw adoption process, which is very similar for land use bylaw to the process that anyone who participated in the municipal development plan process, it's the same process, 3 readings and a public hearing. So I think we did mention that part of the purpose of the review was to ensure that the land use bylaw is consistent with the requirements in the updated now a couple of times Municipal Government Act, MGA, to ensure that the land use bylaw regulations reflect the character of your specific community. We were trying to, where we could, ensure that there was more consistency between the regulations and the land use bylaws of the different summer villages, so that, you know, the rules or requirements for development in one municipality weren't dramatically different than, you know, on the other side of the invisible line. And we have tried to do that through this process, but we have to be mindful and careful as we do that to also respect your existing lot sizes and configurations, some of your unique topographical and environmental characteristics, and then the regulations that have been in effect for years in your existing land use bylaw and previous land use bylaws, which have directed and impacted what your existing built footprint is. So for example, you know, if we were to put a provision in the land use bylaw that said all new development had to be set back from the lake 30 meters, it wouldn't work for you. It couldn't be achieved without making your lots virtually undevelopable. So there is no way to create a single land use bylaw for all of the municipalities around the lake that is exactly the same. It would create a whole bunch of harm and I think undue hardship for you. So we have to work with what we've got and your existing built footprint and the desires of the community members within your summer village, and try to work to adjust and adapt and create a land use bylaw that, does incorporate watershed planning best practices, but also ensures that you're able to use and enjoy your property and redevelop your property, taking into consideration your existing lot sizes and what the existing setbacks and requirements are in your land use bylaw. So it's a bit of a balancing act, some of those things, and in each community it is definitely a little bit different. So one of the things you'll notice or have noticed as you have a look at the draft land use bylaws is that the structure is a fair bit different. I've never really liked land use bylaws that have a bylaw and then a bunch of schedules that kind of drive me crazy. I feel like when you open the bylaw, it should be the bylaw. So we've restructured the document to put it into a format that I think makes it a little bit more readable and easier to use. At the beginning of the document, there's a one-page introduction that just talks about land use bylaws and how they're intended to be used. And then we put all of the definitions up front. And then we move through the procedural components of the bylaw in the first part of the document. Once that sort of is sections 3 through 8. And then we get into the general and specific regulations and then the provisions that are applicable to each of your existing land use districts. And I like the map at the end. It's easy to find there. And then we've provided a bit of information about recommended setbacks. And we've been back and forth in our office about that Appendix A with the recommended setbacks. And I think before we get to the end of this, we might end up having to pull that just because of some of the recommended setbacks in that particular chart just may not work for your municipality. So Brad, that's a note to you. You and I will need to have a further discussion about that. And if we're going to use that, I think we need to clarify that it would apply to a scenario where there were new lots or new development, especially in relation to the setback requirements adjacent to a water body. All right, so I'm just going to take you through kind of quickly here, hopefully not too quickly, a bit of information about each of those sections of the document and where some of the information, if you're looking for it in particular, will be located in an attempt to help you as you go through your own review. I mentioned that the first part of the document is a user guide that just provides some information about interpretation, about our processes, and how to understand some of the specific terms when they're used in a land use bylaw. Because some of the terms have a different interpretation in a land use bylaw than they would in common usage. The introduction section has information about the title of the bylaw, as the bylaws all have, information about when it will come into effect or when it commences, and then the repeal of the existing bylaw. And then it provides some information about the purpose of a land use bylaw. Specifically, the purpose of your bylaw is to prohibit or regulate and control the use and development of land and buildings within the municipality and to achieve the orderly and economic development of land. This section also has application, conformity, compliance, and severability provisions. The interpretation section, you'll notice in this bylaw, is significantly expanded upon from your existing land use bylaw. This is an area where we did seek to try to, as much as possible, ensure consistency amongst the different municipalities around the lake in order to ensure that when we're using these terms in relation to subdivision and development processes, they're being interpreted in the same way. And that was just to try and simplify things for everybody and ensure that there is a little bit of consistency there. You did not have a lot of definitions before. And I find that with land use bylaws, that is often one of the challenges in terms of interpretation and also in terms of enforceability of the provisions in the land use bylaw. So we always look at and spend a fair bit of time on the definition section in order to ensure that the terms that we're using in the document are defined so that you know what we're talking about. And we also try to, as much as possible, in areas where we think that the term, which is very specific to a land use bylaw, might be difficult to interpret, provide a graphic to assist with that. So as you're going through, have a look at those things and let us know whether or not the graphics are beneficial for you, or if they're confusing. We'd love to get your feedback on that. Or if there are areas where you think that there would be more benefit for us to provide some additional graphics, let us know that too, and we can work towards trying to assist in that regard. So it's land use bylaws are our bylaws, right? They use a very specific language, and as a result of that, they're not as easy or enjoyable to read as, say, a municipal development plan. And part of that is to ensure that when we're writing the provisions in these documents, we are not creating scenarios which are too open to interpretation and therefore resulting in potential loopholes, right? That could create for us scenarios where development that we intended to not allow could happen because we weren't clear with the language. So it's a bit tricky, the writing of the regulations in the land use bylaw, and where sometimes things seem to be a little bit convoluted. Sometimes that is a deliberate tool to ensure that we're addressing a specific problem that we have experienced in another municipality or we're aware of in your particular community. So part 3 deals with authorities, and it just identifies the roles and responsibilities of the different organizations that will implement and enforce the regulations in the land use bylaw. So for example, your municipality has a development authority or development officer, a subdivision authority, there's a subdivision and development appeal board, and then there's roles and responsibilities in terms of administering the document that lands specifically with council. So it just provides a little bit of information about how those processes are undertaken and who is responsible for the decision-making authority in relation to implementing different parts of the bylaw. Part 4 provides information about how the land use bylaw can be amended or changed. This is, from the perspective of your existing process, it should be quite similar from what has been required in the past. But your existing land use bylaw didn't have a whole lot of information that explained that process or clarified what the requirements would be if someone were to make application to amend the bylaw. So we've expanded on this section a fair bit too, in order to provide more information to you about the process and to ensure that you can keep us accountable to make sure that we follow those procedural requirements correctly. And then it also provides some more information about what the expectations would be in terms of information to support the application and where council fits into that process. So it doesn't change the process so much, but it's trying to make all of these things much more transparent. Part 5 deals specifically with development and the development process. It provides information about how development will be controlled or maintained within the municipality. In this section, we always have to include provisions that indicate what types of development do not require approval or development permit from the municipality. And then really, I guess the important point here is that if the thing that you want to do on your property is not identified as one of those developments that does not require a permit, then the development you're contemplating on your lot likely requires a development permit. So all development must conform to the regulations in the land use bylaw unless you've applied for a development with a variance and a variance has been granted. And anything that is not identified within that development not requiring a permit section must receive a permit. This section of the document, part 5, also provides some information about how the municipality, the Summer Village, will address existing non-conforming buildings and uses, because we do have provisions to address those types of developments that are in every municipality, historic developments. And then it provides some information about what development permit application requirements will be. And these sections in here are significantly expanded. And we've done this quite deliberately in order to ensure that when development occurs, and demolition is a type of development, we can mitigate potential negative impacts as a result of those developments. So in relation to demolition in particular, if you require a development permit for it to go up, you need a demolition permit for it to go down. That's the easiest way to think about that one. And that enables us to ensure that if we have an old structure that maybe has asbestos in it, we're dealing with those things appropriately. And it also enables the municipality to manage or mitigate potential negative impacts on your road. There are some of the changes to the Municipal Government Act that have occurred in the last 5 years relate to requirements for timelines for development and subdivision applications. One of the new sections that we've included is a notice of complete or incomplete application. And that's a procedural change that all municipalities are required to provide for in their land use bylaws. So we have to indicate how, if an application is received, we are providing notice to the applicant indicating whether or not it is complete or incomplete. And we have 20 days from the date that it lands in our office to do that. So that's a section your bylaw didn't have before because your existing bylaw was developed before that requirement came into effect. And then we have also expanded upon and provided more information about how notification will occur when a development permit is issued. The other sections that we have expanded upon or revised include providing some more details or information about what types of conditions might be applied to an approval for a development permit. And then we provided some information about what a development agreement is and when that might be required. We've also provided clarification about when a permit comes into effect, so when it becomes a valid permit. And then we have provided some information and some, I guess, parameters around what types of variances to the requirements in the land use bylaw the Summer Villages Development Authority may or may not issue. The important one that I wanted to flag for you as we go through the meeting today relates to building height. The way that the document is drafted right now, we have not provided the development officer or development authority with the ability to issue a variance for building height. So that's something I'd like you to think about. And if you have any concerns about that, let us know because we need to report back to council and let them know what your thoughts are on that one in particular. There's just on this slide a little bit of additional information about the types of developments that do not require a permit. And I'll just leave that for you there to have a look at. If you have more specific questions about that section, I'd encourage you to have a look at part 5 in the document, in the specifically development not requiring a permit section, and have a peek at that and see if you have any concerns or any clarification is required. So part 6 is a new section in the document too. You didn't previously have any information about subdivision and the subdivision process in your document. This doesn't change the procedural requirements, it just provides you with information again. And one of the reasons we include that is because we have to provide some we have to in the land use bylaw include information about how we are determining if a subdivision application is complete or incomplete within 20 days of receiving it. So we need to have that in all of our land use bylaws. But we also included additional information about the process for subdivision so that we could be more transparent about that as well. Part 7 provides information about subdivision and development appeals. And similarly, it doesn't change what the process requirements are under the legislation. It just tries to make this more transparent so that if you are in a situation where you need to initiate an appeal, some of that information is available to you. One of the things we wanted to note for you, and this is one of the most recent changes to the Municipal Government Act, is that previously under the legislation, subdivision decisions, depending on the type of decision that was issued, so proximity of the affected site to a highway, to a body of water or water course, and there are some other factors that are taken into consideration, whether or not it's in a green area in the province. What are some of the other ones? There's a few others as well. But some subdivisions, when they are affected by this set of features or qualifiers, instead of being appealed to the local subdivision and development appeal board, now or have been since at least '96 appealable to the province, to the municipal government board. One of the recent changes to the legislation is that the Municipal Government Board has now been renamed. It is now called the Land and Property Rights Tribunal. So if you see a reference to the LPRT and you're familiar with the MGB acronym, it's the same thing. It's the new version of the same thing. And it is the provincial appeal body that used to only hear subdivision appeals. The other significant change is that there are now some types of development permit appeals that the appeal body will be the LPRT. That was not the case in the past. In the past, the only opportunity or appeal board that could hear a development permit appeal was the local subdivision and development appeal board. So this was a substantial change into the legislation, and we needed to update this section to reflect that change as well. Part 7 deals with enforcement specifically, and it provides more detailed information about what types of actions the development officer can take in order to enforce the regulations in the bylaw. It also provides some information about the rights of the development officer to inspect or enter a property to ensure compliance, and it provides information specifically about the tools that are available to a municipality to deal with enforcement. So things like violation tags, violation tickets, and then stop orders. And then we get into the regulations part. So the first part of the document, the first 8 sections really are procedural pieces of the document. And we have expanded on them significantly, in part in order to ensure that they are consistent with the new legislative requirements, but also to try and ensure that the document, again, is more transparent, and that the steps that will be undertaken are there in the document for you as a community member, so you know what's going on. You have a better understanding of what the expectations will be at time of application and with those application requirements. And then it also, I guess, makes it easier to ensure that, you know, as people change within the administrative office, as is, you know, ought to happen from time to time, the people administering the document have that information available to them too, and that should help to ensure consistency in terms of how it's being interpreted and applied in the administrative office and in our office as well too, as the subdivision authority for the Summer Village. So in the general regulations section, this is a section that provides specific guidance about how different types of developments can be situated on a lot. So we have proposed some new sections or expanded significantly some sections that deal with different types of development. The yellowy orange boxes on this chart here identify those areas where they're either new or they've been changed substantially. And so I would recommend to you that you have a look at those sections in particular and just make sure that those changes are changes that you think are appropriate for your community and you don't have any concerns with them. You'll be able to access this through the recording that will be linked on the website. We maybe will also send a PDF of the presentation to Sylvia so that you can just download that too and have a look at that rather than having to listen to all of this again if you're looking for a specific slide. So the ones that I want to spend a little bit of time on with you today are the ones that we've identified here as highlighted. The first one here is the section that deals with what types of accessory buildings and where accessory buildings can be located on a lot. So an accessory building really is any type of structure other than your cottage or your home on your lot. So your dwelling is the main building, because you just have really the 2 residential districts, not taking into consideration the green area. And then anything in addition to that would be considered an accessory building or use. So in this section, one of the things that we wanted to flag for your information and to try and get some feedback from you about is that one of the things that we've done in order to, I guess, keep the character of your community as consistent as possible, and also to try to ensure that we are minimizing the amount of non-permeable surface on your lots, which does have a relationship or impact on your lake water quality. Because more surface water can run off of your lot and into the lake. Although in speaking with your council, I understand that some of you have very, very sandy lots and a lot of that water is being absorbed immediately into the ground. So that's perhaps a lesser problem for some of you than others. But in this section, we have identified a maximum number of accessory buildings that would be allowed on a lot without an approved development permit. So previously in your land use bylaw, you had a provision that talked about, you know, what size accessory building you could have on a lot without a permit. We've kept that, but then we've also said that you can't have 12 of them. You can have a maximum of 2, and that you need a development permit. We have also said that even with a development permit, you can't exceed more than 2 accessory buildings on the lot. One of the other things I wanted to mention too for you is that in this section, we've indicated that accessory buildings on lakefront lots, and I think all of you just about, not all of you, but all of you just about, are lakefront lots. Your accessory buildings would only be allowed in the rear or side yard. So this is a slide where we have identified a pole, and Brad, maybe I'll turn that over for you for a second here to see if we can make that happen.
That should be visible.
Yeah, I can see it. You should have a poll pop up on your screen. The question here is, how many accessory buildings should be allowed on a residential lot? 1, 2, 3, more than 3, or not sure. So I'll give you a minute here to have a look at that and see whether or not you have any opinion on that particular matter. And if we find that these are just not working very well, one of the things we can do is just, I think I had mentioned this at the beginning, was just update our SurveyMonkey poll to include these questions.
We got about 10 seconds, Jane, before it's about a minute and a half. So maybe we'll end it at that point.
Sounds good.
All right.
Looks like we've got 3 responses, and they're all different. So 1 for 2, 1 for 3, and 1 that says not sure. So we'll add that one to our SurveyMonkey poll too, or questionnaire, and after you've had a little bit more time to think about that, we'll give you the ability to respond to that through the survey. I think that's good, Brad.
Yeah. All right.
Okay. One of the things that you maybe want to think about in relation to that one is, what is an accessory building, right? And what sorts of things would that enable you to have or not? And we've tried to separate things like hot tubs and wood storage sheds, because that's something that came up in our discussions with council, and arbors or types of structures you might have for providing shade. And those are different than what we're talking about with an accessory building, which most specifically would be a building that has 4 walls, a roof, and is enclosed. So garages and sheds and the like. The next section that we wanted to flag for you is 9.5 environmental protection. So this is a very new section for you in your land use bylaw, and this is a section that we're trying to include in all of the land use bylaws that we're working on right now around the lake, to ensure some consistency where we can, and also to help implement where it's appropriate and in a way that's appropriate the recommendations from the Pigeon Lake Watershed Management Plan, and then what's in your municipal development plan and the new IDP. So this section outlines wetland assessment requirements. It outlines permit requirements for shoreline modification. It also discourages non-vegetative modifications to the shoreline, except those modifications that are necessary to prevent erosion, so for erosion protection. And then it provides some regulations relating to adding sand adjacent to the bed and shore. So specifically, some of the shoreline modifications that are identified here, if it is to occur, that type of a modification, the requirements are to incorporate revegetation and the use of soft landscaping elements. So that's that permeable surface, and to incorporate low impact development strategies, and to minimize the use of hard landscaping elements because those hard landscaping elements, pavement, concrete are non-permeable and increase the amount of direct runoff into the lake, which has an impact on your lake water quality. So, you know, in the past, we sort of talked about these are the sorts of things that we need to do when we redevelop or develop on our lots to protect our lake and to protect your investment in your property and your enjoyment of the lake. But the land use bylaws have not historically had specific direction that explains how or what you can do in order to address and develop in this way. So we're trying to, in the land use bylaw this time, provide some more specific or detailed guidance or information that will enable you to design and redesign as you redevelop on your lot in a way to minimize some of those impacts and protect your lake. (9.6) is erosion and sediment control. And the purpose of this section is to ensure that as redevelopment occurs within your community, we're also thinking about during construction and then after construction, how water is being managed on the lot. So there's a requirement now for an erosion and sediment control plan for developments that would affect drainage on the site or onto an adjacent property. We've tried to be pretty specific or clear about when that would be triggered and when it wouldn't, and really it does relate to drainage. So if what you're proposing to do wouldn't affect drainage on your site or on an adjacent property, then this wouldn't be a requirement. But if it would, then it's something that we need to be planning for and designing to control. So the types of developments that would require an erosion or sediment control plan with the application are stripping and regrading, like significant regrading, moving, depositing, or storage and removal of topsoil or aggregate fill, those sorts of things. Or if you were building a new cottage or dwelling, because it will change drainage on the lot. If you're doing substantial landscaping that involves hardscaping features and those sorts of things that affects drainage, then that might require an erosion and sediment control plan, depends what you're doing there. And then we've also identified in this section what a erosion and sediment control plan would entail so that you know what you need to include with that. So some of the requirements for an erosion and sediment control plan would be a description of what the proposed disturbance is, and then they're intended to outline control measures to minimize erosion and runoff, and these don't have to be complicated. You know, silt control, fencing, and those sorts of things can be sufficient in many cases. It also needs to outline control measures for dust, noise, and light if you're doing substantial construction on your property to minimize the impacts on your neighbors. And then identification of the types of vegetation on your lot that will be retained and how you're going to protect existing vegetation that's you've indicated as something that you're going to retain so that it will survive after the construction period. And then there's some additional requirements. So I'd like you to have a look at that section too as you're doing your review and let us know if you have any questions about it or if it's unclear about when it would be required or when it wouldn't or what it would entail. And we can work through those pieces too. 9.9 relates to flood risk. So you guys are really close to the lake and your existing development setback is not very big. Your buildings can be located quite close to the lake, and I think many of them are. And as a result, some of you may have in the past or are currently dealing with a situation where your buildings on your site are impacted by high water table on the lot. So there is a new provision or regulation in the land use bylaw that's intended to address that particular situation. And the regulation is that no development will be issued for a structure with a basement or crawl space that's less than 0.6 meters or 2 feet above the high water table of Pigeon Lake. And our understanding of that at this time is that it's 850.1 meters above sea level. So it gives you something to work with when you're designing or redeveloping your lot. And if you have those numbers to work with to begin with, it makes this a whole lot easier for you. So we've tried to provide as much information as possible so that as you're doing your design, you have something to work with your contractor to ensure that you're not going to run into a situation where your beautiful new build is susceptible to high water table and gives you issues moving forward, or you end up with some pumps that are running 24/7. We've seen in other communities that have similar types of issues with the high water table, how that can be a real bother, not only for you as the landowner, but for your neighbors too. So identifying or providing this information up front should make it a little bit easier as you do your redevelopment or redesign of your lot. but that one's one that we flagged for your input as well. So if you have any thoughts about that, please let us know. 9.10 is grading, stripping, and drainage on lots. And what we've indicated here is that development permits and lot grading and drainage plans will be required for development that alters drainage. And I talked a little bit about what those types of developments would be. We've also prohibited grading that would impede or interfere with the natural flow of surface water onto adjacent municipal lands, public road ditches, or neighboring properties. So there were requirements for this before, but we've tried to be a little bit clearer about these things just to make sure that it's very easy to understand that the water's got to go in a way that's approved by the municipality. It can't go onto your neighbor's lot. Like I said, even if your neighbor agrees to it today, you may have a new neighbor down the road that has different plans for the property and they don't, and then we have all sorts of problems there. So the water needs to go in a direction that's approved by the municipality, and then it needs to continue to do that. The flow of drainage cannot be altered without approval from the municipality to make sure that there isn't a negative impact on municipal infrastructure or your neighbors. And as much as possible, we're trying to control and mitigate direct drainage from properties, lakefront properties, towards the lake as well. So some of the requirements for those lot grading and drainage plans include identifying pre-development and proposed grades on the lot for big construction, to specify design elevations, surface gradients, and swale locations if it's necessary, to demonstrate how runoff will be controlled on the site, and then to include any drainage information that's required by the development authority, so that once we move through all of this process and you have an approval, there's something there that, say, 2 years from now or 5 years from now, if there's an issue, you can hold up and the development authority can hold up and say, nope, we did it as we were supposed to, and whatever this other problem is, it's somebody else's problem. Or if there's an issue, we can identify, where something's gone wrong and get that corrected and deal with the enforcement as well. Because that's, I think, an issue that we've had in communities where we didn't require lot grading and elevation plans or lot grading and drainage plans on a lot, is that everybody kind of did their own thing and the municipality didn't provide input into that process. And then as new construction occurred, it has had a negative impact on adjacent properties that were maybe built at lower elevations. So we're trying to deal with that now, so that moving forward with new construction, we can get on top of that issue and we don't have those same types of negative consequences, entirely unintentional, but negative consequences on neighboring properties too, because they're very difficult and can create very uncomfortable situations between neighbors and damage. So the next section we wanted you to have a look at is home occupations. So we have provided for something called a minor home occupation, which is like a home-based business, but they're absolutely invisible. they're an invisible type of home-based business. So they're the types of work you can do out of your house that doesn't require the employment of off-site employees. So you can't have employees other than people that live in your building, so in your home. It's intended to have no off-site impacts whatsoever in terms of noise, vibration, smoke, dust, odor, etc. None of your business activities can be carried out outside of the dwelling, and you can't have any outdoor business activity or signage, display, or advertisement. But if you want to work from home, you should be able to work from home. I mean, the last year and a bit have taught us that. It's something that we can do, and we likely are going to see more of in the future. So we just wanted to make sure that the land use bylaw addressed that change to how we're working and living these days, and provided for it in a way that was going to manage potential offsite impacts. So some of the other provisions say that you can't change the principal character or external appearance of your building, and you can't disturb the peace, quiet, or other amenities of your neighborhood, so your neighbors. So I don't think that this will change how things are occurring today. We just wanted to make sure that we have provided for this, so there wasn't an issue with this in the past. Some land use bylaws in other municipalities will provide for major home occupations, and major home occupations can have visitors to the site, so there's some increase in parking, and some of them even provide for the business activities to occur in an accessory building, or for you to have one non-resident employee. We haven't provided for any of those types of businesses to incur on your lots. Our understanding in talking with council and administration is that's not something that's occurring today, and they didn't want to open the door to that. So if we're wrong about that, let us know, but that's the way that it is drafted at this time. The next one is our objects prohibited prohibited in yards. So we've expanded on this section a little bit. I don't think that these have been issues in the past, but we just wanted to make sure that all of these things were quite clear. The one thing that came up in our discussions with council and administration were portable or permanent gas or fuel tanks larger than 100 liters. And I guess this is another one that we have identified for you guys. And maybe we won't do the poll, Brad, for this one, but we'll add this one to our SurveyMonkey survey. The question really that we have for you is, historically or currently, do you or your neighbors have gas tanks on your site larger than 100 liters, say perhaps for your boats? And I think that's the only context where that might happen at the lake. The way that the land use bylaw is drafted right now, they would not be allowed moving forward. And your existing land use bylaw is silent on it. But I think it's something that's come up within your particular community in the past. And so we were looking for a little bit of direction from you about what your opinion is on that particular matter. If a fuel tank of that size leaked that as close as your community is, there would be impacts in the lake. And that's why the direction at this time is to not allow them. So I'll leave that with you two to think about and provide us with some impact. But our recommendation to council and administration was that they not be allowed on residential lots. They're also not particularly safe. So we don't need a whole bunch of fuel stored where people are sleeping, just in case. So the next one we wanted to chat with you a little bit about too is pools and hot tubs, because I expect that there are those of you out there in the community that have a lovely hot tub, and that those of you who do have them prefer to have them with a view of the lake rather than a view of the road. A little bit more private and a little bit more picturesque for sure. So we have provided for hot tubs in the land use bylaw, and we have allowed them to be located on the lake side of the lot. However, we have indicated that they have to be set back 6 meters from the lakeside front property boundary. So this is something I'd like you to think about too, in relation to yourself and your neighbors, and whether or not that's going to create a conflict for you. If you have an existing hot tub and it is not in a location that would be consistent with this, there would be no requirement for you to move it. It would be an existing non-conforming use. But it would be, this provision would affect you if you got rid of the hot tub and wanted to put a new one in. Then the provisions in the land use bylaw, if they're approved, would apply, and you would probably have to move the hot tub back in order to ensure you have the 6 meter setback. A 6 meter setback for buildings from the bed and shore of a lake is not a very big setback. If we were developing a subdivision adjacent to a lake today, the setback requirement would be 30 meters. So you guys are already pretty darn close to the lake, but you are. It is the way that your historic development pattern has been. I think that, ideally, in order to protect your property and also to ensure that we're trying to work together to minimize impacts on the lake, 6 meters should likely be maintained as much as possible. Yeah, it's a pretty small setback, but we're working within what you have been allowed to do in the past, and having to respect and understand that most of you already, with your existing developed lots, built with an understanding that the rules that were in effect the time that you did your development would be, something similar would be in effect when you went to redevelop your lot. So we're trying to work within your existing built footprint, but also do what we can to try and minimize shoreline disturbance to those riparian areas that are so important to the function of your lake, and protect your lake water quality. So this was a tough one. And we're looking forward to hearing your input about this particular provision as well. CCANs. So CCANs in your community, they can't be used as a principal building or dwelling. They can't be a garage or any of those things either. We have provided for them in one case, one situation only, and that is as a temporary accessory building during construction. So if you're rebuilding on your lot, or you're building on your lot and you need a place to store your tools and building materials and equipment that's secure, then you could get a temporary development permit for a CCAN to do that. But as soon as construction is complete, the CCAN must be removed. So that's I think a little bit of a change from your existing land use bylaw. We've tried to clarify that CCANs are they're not going to be allowed unless it's to help make sure that your construction materials are secure, and only on a temporary basis for a short period of time. Site coverage and landscaping. So this is a new section 2. And in this section, we've provided a requirement for landscaping plans, and then we have tried to clarify, provide some guidance about what we're looking for with a landscaping plan. And really, we're not talking about requiring approval for you to do gardening, or any of the natural lawn maintenance and care types of activities that you would enjoy and do on your lot. I don't know, maybe some of you don't enjoy them, I kind of do. What we're talking about is landscaping, significant landscaping that again would alter drainage. And really that's the qualifier or the trigger for these sorts of things, because it could impact the quantity or quality of runoff leaving your lot, going towards the lake, or going onto your neighbor's property, or going onto the road. So depending on your lot and the way things are situated in terms of lot grading. So if you are proposing to do substantial landscaping on your property, then you may be required to submit a landscaping plan. And that's for the same reasons that you would be required to submit the lot grading and drainage plan. And it's just to ensure that the water is going to, once you're done your development, drain in the direction that it needs to, and we're minimizing as much as possible that surface runoff. So have a look at that section 2. We've tried to leave that one a little bit flexible so that it's the development officer has the ability to ask for it if they're quite confident that in speaking with you about the development that you're proposing, it is going to alter natural drainage patterns on the lot. So they can ask for these things, but they don't have to ask for them. So it's flexible enough to make it so that they're only asking for it when it's something that would be necessary to ask for to minimize potential negative impacts offsite. All right, and then this section deals with site coverage and landscaping, and it's the purpose of this section is similar to those other sections, and it's being implemented in an attempt to ensure that we're minimizing the amount of direct surface runoff towards the lake or towards adjacent properties. So in this section, what we've done is we've looked at what types of developments you might do on a lot that would have a non-permeable surface. So your building is a non-permeable surface. And then for the most part, your driveways or patios that are concrete pads or other types of hard landscaping would also have a non-permeable surface. And we've identified a maximum percentage of the lot that can be covered with those non-permeable surfaces. In this instance here, the amount of the lot that could be covered with those types of purposes or surfaces, would be 60%. And then we've identified a requirement for 25% of your lot to be covered in vegetation or trees and shrubs, those sorts of things, so that we're ensuring that all properties have some of those natural buffers and filters to help manage the runoff on your lot and encourage on-site filtration and on-site, containment of the surface water. So that's what this section provides some guidance about. In your municipality in particular, you already have a really low lot coverage percentage for buildings. 35% is quite small. So it gave us a fair bit to work with in terms of your non-permeable surface maximum coverage. So I guess I want you to think about that and think about the numbers and your properties, and let us know, if as we were running through our example scenarios, which we did, the numbers wouldn't work for you. We think that they will. We think that they'll work for most of you, hopefully all of you, and not create a situation where you won't be able to develop or redevelop in the way that you'd like, while still trying to minimize and mitigate that surface water runoff. So have a look at that and then let us know if you have any concerns. These things are, we've talked a lot about how important it is to try to redesign with the lake in mind. And we're trying to, with these types of new regulations that wouldn't apply in other types of communities, they apply at the lake, provide better tools to help you as you're developing your own plans and for the future of your property, to give you guidance to help you figure out how to implement some of these things to be lake-wise, I guess, in your redevelopment. enable you to develop, the Dream Lake property that you have in mind, and take some of these design mitigations or design tools to minimize potential offsite impacts. So we're trying to be flexible enough in these provisions to not, be too restrictive of your redevelopment of your lot, and enable you to do what you need to do, but give you some guidance to help address some of these things that you may not have thought about when you're doing your redesign, that shouldn't have all sorts of significant additional costs for you, but if we didn't give you some of these guidelines, you just maybe wouldn't think to do them. So have a look at those things too, and just let us know, is there enough information being provided to make this implementable for you? Or does it feel like there's big holes still that would make it difficult for you to do if you were thinking about redevelopment? Because we want to make sure that we're successful in this too, right? That we're giving you the information that you need, without just saying, hey, you have to do these things that you didn't have to do before, and then leave you kind of struggling to figure out how to make it happen. So yeah, we're looking for some feedback in that regard too, because if it's not something that is reasonable for you and is easy enough with the right tools, then it's going to be something we struggle with moving forward, and we don't want to create that scenario either. There's just a couple more here. This one is relating to solar energy collection systems. We've indicated that they'll be allowed as an accessory development. You can't create a solar array on your lot exclusively. Ground-mounted solar collection systems can only be located in a side or rear yard. So you can't put them on the lakefront side. And then the summer village, we've indicated that, if you install these solar panels and then your neighbor builds something that impacts your ability to use them, the summer village is not going to be held responsible for that. So that's just a warning or disclaimer there for you. And then we've indicated as well that you can't install a system connected to the grid unless you provide evidence that the franchise utility provider has been informed of your intent to do so. This is also something that's beneficial for the emergency services providers in the neighborhood to know, just so that they know where they need to take this stuff into consideration if they're responding to a call. Guest house suites. We've provided a maximum area for a guest house suite that would be allowed, or guest house. I think that's how they were referred to before. And we've also indicated that the maximum area of your guest house can't exceed the floor area of your principal buildings of your cottage or home on your lot. Except in a situation where the guest house is being built as a second story above a garage. So say if you are, lucky enough to have on your lot enough room for, say, a 3-car garage, and you want to put a suite across all 3 of the bays, if that would exceed the square footage of the cottage that's on your lot, then you could do that, because it's not increasing the amount of non-permeable surface on the lot, right? It just is utilizing the existing footprint of your garage, and you could be building up that sort of thing. We haven't made any changes to the number of guest house suites that are allowed or the location requirements. Those things we kept the same. Wind energy conversion, we did provide for them in this land use bylaw. So we said you can have a roof mounted or ground mounted wind energy conversion system. There's some maximum height requirements so that it doesn't stick out too much. We've provided for 1 micro wind energy conversion system per lot, with the ability to have a second one if there's adequate room on the lot at the discretion of the development authority. And because it's at the discretion of, that would make it appealable by the neighbors if you had concerns about it. And those are really the newest, I think most substantially different provisions that are in your land use bylaw that weren't there before. And we're trying to modernize the bylaw and address those types of uses that we could see potentially being applied for, so that, if in the future someone came in and wanted to develop one of those uses that your land use bylaw was silent on in the past, the development authority or development officer has some guidance to deal with those things instead of having to wing it, which was what happens, if your land use bylaw doesn't provide for all of these types of uses. So it gives you the ability, in the event that one of these types of developments is proposed, to ensure that we're minimizing offsite impacts and we're regulating it in a way that's appropriate for your type of community. Some of those provisions we may never have to use. I mean, that's quite possible, but in the event that the development officer receives an application or an inquiry, it's better to have something in there to deal with it than to not have anything in there and then we have concerns down the road. So the last thing I wanted to chat with you about was the land use district map and the district provisions themselves. So you'll notice here One of the things that we've done with the land use district map is that we've identified the new land use district that was approved by amendment. That's that R1 district. That's not new in this document. There was an amendment that was undertaken to create that district and rezone that piece of land, but it was in a separate document. It was in the amendment, and so we've just incorporated that into this document so that it isn't lost. And then I think the biggest change here, the only thing that is different here from the existing land use bylaw as amended, is the implementation here of a spillways district. So that is that little blue area. And in discussions with administration and council, we talked about there being different types of public lands within the community. You have your greenbelt district that is used in a very specific way. And then you have these other little pieces of land that are used in a different way too. And those are those areas that one of the uses of them is to provide access within the community to the lake. The other is to provide for drainage towards the lake where necessary. So that's, we've tried to just clarify in the mapping in the district provisions that these are slightly different public areas with slightly different intended uses. So I want to encourage you to have a look at that new spillways district too, and let us know if you have any questions or concerns about that one as well. Brad just forwarded me a question here. Actually, maybe forwarded it a few minutes ago. It says, the environmentally sensitive areas along the lake are not mentioned, although they exist. R and R1 are considered equal. That is a lake lot versus 61 acres. So they're actually different in that the minimum lot sizes for those districts are quite different. And that's why I'm going to go back a slide, the R1 and the that's why the R1 district was created. So the R district provides for the lots in terms of size, length, width, area that you guys have all along the lake shore today. You know, as we were going through the amendment process for that R1 area, one of the conversations or discussions that we had was, you know, if we applied that R district to that R1 area, how would that change? Or what types of development density would that enable within that area? So then we had a lot of discussion back and forth about the history of the annexation and what was intended at that time, and then what type of density would be appropriate within that area. And that's why the R1 district was created. It was determined at that time that if we put that land that was annexed into the summer village some years ago into that R district, it might inadvertently provide for or allow a significant increase in density in that area. And that was never what was intended. It wasn't intended with the annexation. And it wasn't, I don't think, the will or desire of the community to see that moving forward either. So the R1 district was created. It has it has very specific requirements in terms of maximum density for that parcel of land. And then it has quite specific requirements relating to what would be necessary in terms of supporting information at time of subdivision, and then setbacks from different features, environmental features like wetlands, water courses, and the like. And that's because we recognized at that time too that there was substantial wetlands within that area, which is what makes that area in particular environmentally significant. So they're very different districts. I guess that's my short answer there. And the provisions that were applied for or included in that amendment have been carried forward in this land use bylaw. So they continue to be very, very different districts, even though they both allow for residential development and uses. Brad is just mentioning to me in the chat there that there's a couple more questions, and I'll just finish up the last couple of slides here and then we'll run through those. So our R district and our R1 district, both of them have the same types of permitted and discretionary uses. Because we have provided now for a minor home occupation as a different and unique type of use, we've included those as permitted uses in both residential districts. And then because we have specific provisions that relate to solar energy collection systems, we've included that as a type of use as well in both districts. And then CCANs, solar energy collection systems, wind energy conversion systems, and for some reason, buildings and uses accessory to a discretionary use were missing from that district. We've included all of those in both the R and the R1 district, just to tidy it up and make sure those new uses are carried forward. So you could have a permit, a development permit for them. We didn't make any changes to the lot area requirements, to the building site coverage, or to any of your setbacks. And that was very deliberate because we didn't want to impact your existing developments. So we wanted to respect and carry forward the approvals essentially that you already have that were based on those types of provisions in your existing land use bylaw. We didn't want to create a problem for you. We did delete some regulations or additional words that were in these provisions because they were in the wrong spot. So some of them were deleted, others were just put into where they should have been placed before, which was the general regulations section. If you see something missing that you're concerned about, get in touch with us and we will let you know whether or not it was deleted or if it was just relocated and just provide that additional clarification for you. The spillways district. So previously, those areas that are identified now as that light blue area, instead of being identified in the green belt area, because that's a very specific and different type of district, they were actually all in the residential district. And that is not, those are not areas that are intended for residential use. They have a different public use, and part of it is an environmental protection function. So instead of continuing on with those areas being identified within your existing residential district, we pulled them and we created this new district for them to recognize their unique function and purpose. So the purpose of that, the new spillways district, is to protect sensitive riparian areas and to facilitate natural stormwater management on lands owned or controlled by the summer village of Argentia Beach. So we're hoping that in doing this, and this is maybe relates back to that question again, we're able to identify more clearly for the broader community that these shoreline areas where the reserve parcels exist are not residential use parcels. They are areas that are intended to protect sensitive riparian areas and where they are today to facilitate natural stormwater management. So hopefully that will address the concern raised in that previous question. We think that that was a good catch by council and administration. Hopefully that will be beneficial for us moving forward here. So that's really the biggest change to the zoning or the district map, the land use district map. And I'd like you to have a look at those things as you do your review, and then we can move forward with that too. I guess the only other thing that I should probably note is that in the spillways district, we have stated quite explicitly that lands within this district are intended to remain in their natural state. So that's the end of the information component of this presentation today. There's lots and lots of information. The land use bylaw that is in its current draft form is a lot different than it was before. And in our opinion and our hope is that the changes that have been made to it will help implement all of the other hard work that your council and administration and you as community members have been doing through your contributions to projects like the Municipal Development Plan and the Watershed Management Plan and the Intermunicipal Development Plan that are now approved and in effect, and that this will be a valuable tool for you to help ensure that as development and redevelopment occur within your community, it is supporting the goals and objectives that are identified in those other future-oriented planning documents. So the next steps for you, I guess, would be we'd like to encourage you to have a look at the draft land use bylaw. It is available on the Summer Village's website. If I know we don't have a whole lot of people with us today, so if you could encourage your neighbors to have a look at it too, that would be wonderful. And then to get in touch with us and let us know what your thoughts are, provide us with your comments so that we can share them with council and administration. And then also if you have any questions at all, send those along to us too. We'll compile all of those and then we'll provide a response or get in touch with you directly if it's something that we think that would be a better way to serve and let you know and deal with those questions. All of the feedback that we receive from you, we will compile into a report so that we can report back to you and that you know that we've done something with all of your hard work. It'll be shared with council, but it will also be shared with the community so that everybody else can see. Sometimes someone will, have a bunch of great ideas and good thoughts, and then they just won't get around to sending it to us. And when we do that, sometimes I think it's reassuring because you can see that somebody else did too, and they did send it to us, and we've addressed some of those things that were issues for you too. So we'll get all of that out to you after you've had a little bit of time to review the land use bylaw in some detail. and then provide it to us. And we also had a survey that we sent out information about in the newsletter that went out. I recognize that you have not had a whole lot of time with that. And I don't know about you, but August for us was vacation time, and we're pretty busy between the kids' soccer and our vacationing and those sorts of things. August seemed to have just flown by for us. So I think that in the newsletter, it said that the survey period was, it would end on August 20th. Is that correct, Brad?
Yes, I believe so.
Okay. So we're just going to extend that. So we'll just leave it open. So if you didn't have a chance to have a look at that and provide us with some information, please don't hesitate to do so moving forward. I think I did also mention that we will add some additional questions. So that the things that we've talked a little bit about today, and I've given you a bit more information about the why and what they are. Hopefully that will make it a little bit easier for you as you're looking at the questionnaire to provide us with a response to those questions. I think Allison also reworked it a little bit too to give you more options in your responses. She indicated to us as we were getting ready for this session that not only did we only have 6 responses, but in those 6 responses, there were a few people that had just skipped over some of the questions. And I think likely it was because we didn't provide you with enough options in the responses. So we've reworked that a little bit, the survey design, to give you the ability to respond as not sure or not applicable. So if you're not sure what the answer would be, our preference would be, it makes it a little bit easier in compiling the results if you just click not sure rather than skip the question entirely, if you don't mind. That was Allison's request, is that I convey that bit of information. If you have already responded to the survey, my understanding is that you all or contact Brad. His contact information is here, and that should enable you to, we'll get you through that. We'll get you through that so we can get your information in there. After that, so once we've got all of that information and we compile the survey results, we'll prepare that what we heard report, we'll share it with the community and council, and then likely we'll make changes to the draft. So the draft that's floating out there right now, don't worry about it. It's not the final product, but we needed to give you a straw dog to have a look at. Way easier for you to have something to look at when you're providing us with input than have nothing right in front of you to be able to provide some feedback. So absolutely, you have a say in this project, and we're really hoping that you'll have a look at the document and provide us with your input so we can make sure that at the end of the day, we end up with a tool for you that is correct and beneficial for your community. It's appropriate for your community, and it helps to address land development matters that are specific to your community in a way that works for you. So Brad had indicated that there was a couple of questions that had come in as I was talking. And I'm just going to turn it over to him for a second to see if he can share those with me so we can try and get you some answers.
Yeah, we had a few questions that kind of popped up in the chat during your chat there, Jane. It's specifically with respect to section 9, which is the general regulation section. And one of the first ones that kind of popped up was regarding the accessory building section, which I believe was 9.1, and that there was a comment that between the 2 different residential districts, the R and the R1, that there should be different limitations on accessory buildings for those two different districts, given that they are different in terms of intended lot size and configurations, and whereas one is lakefront and whereas the other is backlot.
I think that's a good point. I think that's probably something we should have a chat with council about. It's also a much larger lot, and even if it were to be subdivided in the future, there'll still be much larger lots, and it is set back a little bit further from the lake. So the building pocket on that lot or lots will be much larger. So I think that is a good point, and it's probably something that we should revisit.
Okay.
Thanks for that comment.
Yeah. And another comment that came in was, I think it was during the objects prohibited in yards discussion, which was that the lake lots have specific characteristics that are not addressed, specifically the tight quarters, so that are prone to fire, gas tank storage, and so things of that nature shouldn't be allowed within I would assume, sorry, the R district.
Can you say that again? I missed something there.
Yeah, the comment was the lake lots in Argentia Beach have specific characteristics that are not addressed in the land use bylaw, specifically the tight quarters that are prone perhaps to fire and resulting from gas tank storage. And so gas tank storage shouldn't be allowed.
Oh, okay. I think that's a comment more than a question. Yeah, I think that's a good point, and it was something that we discussed with council and administration too. I'm not sure how many properties have historically had gas tank storage on the lots. Didn't come up as something that was common, but it did sound like that is something that is occurring in your community. So the way that the document is drafted right now, it wouldn't be allowed moving forward. So I think that is consistent, that comment, with the provisions in the document, but we'll double check that as well. But I think it is consistent with the direction that we were headed there. I think it's a good point. Yeah.
Another one was regarding 9.5, the environmental protection section. There was a comment, or sorry, a question: can loads of sand be continued to be brought in onto properties? And under 9.5.8, we have in the draft the addition of sand to the bed and shore of Pigeon Lake and or lands adjacent to the bed and shore of Pigeon Lake shall not be allowed.
So I think the answer to that is it depends where the sand's being put. If the sand is being brought in to be dumped on the lot to create kind of an artificial beach directly adjacent to the shore, then the way that this section is drafted, specifically 958, would not provide for that anymore. I do know of a property on the south side of the lake. Gentleman has created an artificial beach, I guess, set back from the lake for his grandkids to enjoy. And then he created a vegetative buffer between the lake, or where the little sandy area is, and then the vegetative buffer and then the shoreline. And the way that this is worded, that could potentially be allowed, but it wouldn't be allowed directly adjacent to the bed and shore. He also created, I think on that property, he graded that in such a way that any runoff would be directed into a rain garden, so that if would would contain the sediment if there was a big rain, and control it towards the rain garden instead of draining into the lake. So could you have a load of sand dumped onto your lot? The answer is probably maybe. But if you were going to do it, it would have to be done, I think, in a different way than it has been done in the past in order to minimize impacts on the lake. Were those the only two?
No, there's two more here at least that popped up. Regarding a previous question about the environmental sensitive areas that I had forwarded to you. There was a comment that the environmental sensitive areas on the lakefront lots, that those exist, and that they're not addressed in the land use bylaw. Just quickly looking at the municipal development plan for the summer village, there is a significant portion of lakefront lots that are within the environmentally significant areas overlay that the province maintains.
Okay, yeah. I have to think about how to deal with that. Sorry, that's what the pause is here. If we were working on a county land use bylaw, which we do from time to time, we would include an information map that identified those areas. We have included it in your municipal development plan, so the information is available. The difficulty with those things, when we're talking about a summer village, is that I can, with a great deal of confidence, taking into consideration the location of your existing lots, I guess I can comment with a great deal of confidence that probably all of your lots are in areas that are environmentally significant, identified by the province or otherwise. They're close to the lake, right? They're within riparian areas. So we have to try and figure out how to deal with that in a way that enables you to redevelop the lots, because you bought them with an expectation that you could use and enjoy them and redevelop them, but try to at time of redevelopment of those lots, minimize the impacts on those sensitive environmental features. So the way that we've approached this right now, rather than just saying, hey, if you're in an area that has that has been identified as by the province as an environmentally significant area, which many of your lots are, you have to do a biophysical, which is what we would do in other situations, is we've tried to provide specific design mitigations to minimize the potential impact from redevelopment on your lot. Because if you do a biophysical and it tells us what we already know, which is you're within a riparian area and it's sensitive, it doesn't often also give us the design mitigation. So that's not so useful for you, and it's not very beneficial for the development officer when they're then reviewing your site plan and what you're proposing to do on your lot. So we tried to approach this in a slightly different way, so that what we were giving you in the land use bylaw, instead of requirements for a whole bunch of additional information, was tools that you could use on any lot to minimize potential impacts to those environmentally sensitive areas, which I think occur probably on all lots, regardless of whether or not they are identified by the province as an environmentally significant area. They're lakeshore lots, right? So that's the focus we took with this. We're trying to keep it equal for everybody and give you tools to have us be able to implement some of those design mitigations to minimize negative impacts on those environmentally sensitive areas and the lake itself, which is a different way of approaching this. And it's not something that we've done in the past, but we've been working with you guys and your neighbors for a number of years. And one of the things that's come up again and again and again is, if you want us to do these things, you have to explain to us how we can do it. Because if we can't, and we can't explain it to our contractor, it's not going to happen. So that's what we did there. If the individual that had that question has some additional questions about that, maybe contact us after, and I can kind of work through with you about the different things that we did there. But the sediment, the lot grading and drainage plans and those sorts of things, the requirements to minimize shoreline modifications or to not allow shoreline modifications, all of those sorts of things are directly related to ensuring that we're minimizing impacts on environmentally significant areas. So I think we're getting at the same thing. We're just looking at it in a different way, and hopefully the way that we've approached it will be a more useful tool for you as the folks that are trying to redevelop or use and enjoy your property. I know that people get really frustrated when we ask them to spend a whole bunch of money on studies that we then don't do anything with them, right? So there has to be a connection here between what we ask for and providing some guidance about how it's going to be used and how it's going to provide benefit to you and your neighbors and the environment. Yeah. Long answer, sorry.
There was one more question so far, and that's with respect to the two different districts. The question was that you had stated that the R and the R1 districts are very different from each other. So the question was, why are they treated mostly equally? I would imagine perhaps with respect to some of the regulations within this, similar regulations within the districts.
So the very different part of the two is that the R1 district, I'm just looking at it right now in the bylaw, is intended to apply to one legal description, one area within the summer village. And you guys remember that, I think, from the map. In terms of uses, there's no reason for them to have different uses. That area is equally as suitable for a dwelling, a home occupation, a public park. I don't anticipate that'll be there. But if there was a reserve parcel taken there, it could be. Public utilities, solar collection, a guest house, moved-in buildings, recreational vehicles, CCANs, temporary, solar energy, wind energy, and then accessory buildings. It's just as suitable for that as would any of the lakefront lots. It's probably more suitable as long as the development that's being proposed isn't happening within one of the wetlands that's located on the site. Might be more suitable than the lakefront lots because it's set back from the lake, right? So we didn't want to prohibit or restrict any of those types of developments in that area because the land itself, outside of the environmentally sensitive features that are located on it, specifically the wetlands, is suitable for all those types of uses. Where it is very different is in relation to that minimum lot area. So in that R1 district, there's a requirement that if a subdivision were to be proposed, each of the lots being proposed would have to demonstrate that they have a minimum of 1 acre of developable area on each of the lots. So that means land that's outside of hazard areas, water courses, water bodies, including wetlands, and the required buffer areas. And we don't have those provisions for the lakefront lots. If we did, you probably wouldn't be able to redevelop many of your lots. But we had to take into consideration, I guess, or provide for the subdivision and development that has historically been approved. So if we had applied these types of restrictions to your existing lakefront lots within the community, it would be, we would be causing undue harm, right? Because you bought with an expectation, you have been able to use and enjoy your property in a certain way, you've been able to develop in a certain way, and to create a provision within that district that made it so that you were unable to use and enjoy your property that way moving forward would devalue your lot substantially and create an issue for you. So these types of things that are in this R1 district that we would apply in a new greenfield area, an area that was undeveloped, have been included for those reasons, but we can't retroactively go back and apply them to the lakefront lots because the development is done. The ship has sailed, essentially. But moving forward, we can do better. And that's what we've tried to do with the R1 district, that residential low density district, because it hasn't been subdivided yet. And so the types of things that would be an expectation to protect a water resource or water resources in environmentally sensitive areas, we have the ability to address in that area now. But that's why they are so different, is that one, we just have to take into consideration what is existing and what has been provided for in the past. And then in the other, we have to try to design with what the expectation would be today under today's expectations from Alberta Environment Parks, what we know about water, watershed planning best practices, and make sure that moving forward, if new development and new subdivision were to occur, we're following that path and those recommendations and those guidelines. I hope that answers the question. If it doesn't, just shoot Brad or I a follow-up email, and we'll keep trying to help. Sometimes I miss the question.
Yeah, there was one comment that came in just now that talked about some historical information being incomplete, but that it may not be a discussion for right here. And we invite you to send us an email or give a call to our office next week, and we can discuss that and make sure that we're completely straight on that information.
Yes, thank you very much. Any others, Brad?
Nothing came in. Perhaps we'll do a last call of sorts if anyone else has any questions or comments. But we will also invite you to, if you think of something a few minutes after this ends, again, to get in touch with us, to send us an email or give us a call next week, or at your convenience, depending on your schedule. I know school's returning soon. So it's going to be a hectic week for a lot of people, but we're here whenever you have a chance, and can, especially after you've had a chance to digest the draft land use bylaw and the information that Jane provided in this presentation.
Because of the time of year it is, and I don't know about your households, but it is a little bit chaotic in ours right now. And I expect that August was for you as well. We haven't talked with council and administration about how long you want us to keep open the commenting period, but I think at minimum we should be talking about at least until the end of September. Sylvia, Randy, Dawn, do you have any comments about that? I don't think we're in a real rush. Am I right? Oh, Brad, you might have to let them unmute.
Yeah.
And I think, in our other projects working with you guys before, I've said I'd rather, we take the time up front. You have the time that you need to have a look at the documents and provide us feedback now so that we can try and work it into the draft. Then you feel rushed and feel like we've rushed you, and then we end up in a situation where we get to the end of the process and we're frantically trying to make changes. So what do you think, Council Admin?
I have a couple of comments. I think some of the questions that have been posed and I think we need to maybe change or add perhaps an additional diagram that would provide a little more clarity to that front property line, because some people are used to the front of the or right to the water's edge, and they think they own that and they can do whatever they want with it, where they really can't. They really still have their front property line. So I think we need to change or add another diagram that spells that out a little clearer.
I think, Dawn, that's something that came up at our last meeting, and I know our office is working on like a little briefing note to share with you guys about that too. And I think we do need to do that. I don't know that it belongs in the land use bylaw, but I think it's something that we need to work through and provide that information to everybody about.
Well,
so that's not off the radar.
We have one diagram. It would be easy to add an additional line to it, and that would help that clarity very easily.
Sure. Yep. That's something we can work on. We'll work on with council and administration and share with everybody as well, for sure.
Other than that, great presentation.
As far as timing, Jane, I think our next council meeting is September the 28th, and it would be nice to hear the results of the survey before that meeting.
Yeah.
So it is the 28th today of August. My dog's making funny noises behind me. Sorry about that, guys. If your meeting, what is did you say the 28th?
September 28th.
September 28th. You will need an agenda package. Sylvia, when would you need that from us?
Generally a week before.
The 21st. So that would, if we did
22nd.
So that would mean that we would have to close the comments. What if we close the comments on the survey on the 15th? So we extend it to the 15th of September. But I think that's not enough time to do the full what we heard report. I think we need to give the community a little bit more time.
Okay.
With the document, so I could get the survey results to you, Randy, for that, and then maybe just an update on this is the sorts of things that we're hearing right now. But I don't know. I don't want to rush people. It's a big document, a land use bylaw. Would that work for you, Randy? It gives you a little bit of input about what we're starting to hear.
Sure.
Without closing it off too soon. Yeah.
Yeah, that works. I think it's important to get them.
Okay.
Sorry.
I don't know what our timing is for when you'd like to have her all wrapped up. Are we looking at bylaw approval in the spring when people are back to the lake? Or are we looking at trying to do the public hearing and stuff over the winter? Each of these COVID years are so bizarre. It's kind of hard to know what the best thing to do is.
I think I'd like to see it sooner than later, because it might or might not affect new development permits.
For next year?
Some areas where because in the last 2 years in particular, we've had a lot of new cottages built. I don't think we've done anything with those new cottages that might be negatively affected by today's changes. I'm not sure, but I'd like to do it sooner than later.
Okay, to keep it with the intention of being ready to go as people are planning and getting their approvals in place for the next construction season.
Yeah.
Okay. So I guess then we probably should be getting the what we heard report, the summary of the engagement comments this round anyway, together for the October meeting. So maybe we could send an update for you to put on to the Summer Village website, Sylvia, that just has a bit of information about that timing and when that's released, and we'll talk a little bit about that. And then a reminder or a cue, I guess, for everybody to look to the website for information about, you know, the moving forward timeline, and go from there. We'll try to keep you posted with updates on the Summer Village website there. Does that work for everybody?
Sure.
Yeah.
Okay, awesome. All right, so for those of you who are in attendance today, I think in order to be ready for the next construction season, it means that we'll have to go through that bylaw approval process over the winter. To do that, I think this is probably the best forum for the public hearing, because it enables you to tune in from wherever you are. If you are lucky enough to be able to go south or to wherever you go, you'll still be able to attend, and we won't be losing those people like we do from time to time when our meetings are not held this way. So we'll try to structure it to ensure that we have the ability to hear from as many people as possible. Does that work for council and administration too? We can help set that up.
Yeah.
Okay, awesome. All right, everybody, I took up a fair bit of your lovely morning today. I think we're at noon. You're probably ready for some lunch and to go sit outside in the sunshine. I want to thank you so much for spending 2 hours with us this morning. I really appreciate it. And encourage you to get in touch with us after you've had the opportunity to have a deep dive into that land use bylaw with your questions and comments. And we'll make sure all of that information gets responded to and compiled and shared back with the community and with council and administration.